is Captain Chaudhari. Today I am going to discuss analytically the difference between the Hague Rules and Hague Visby amendments. First of all, why it was necessary to bring the amendments. What were the drawbacks of the rules? I am going to discuss all of them analytically. Hague Rules came in 1924, basically to harmonize the differences between the cargo interest and the ship interest. But these rules had certain drawbacks. For example, it was said that the limit of liability was too low, actually 100 pounds, 100 sterling pound. It was rather too low. That was one thing. And second thing, for certain faults, which were even intentional, the carrier had only limited liability. Hague Visby amendments came in 1968. These amendments increased the limitation of liability rate, that was targeted earlier. And then there was this 1979 protocol, SDR protocol it is called, and that agreed for universal or global or more stabilized unit of measurement. SDR was introduced. They also thought that the rules should be modernized, looking at the growth of the shipping, particularly in respect of containerization. The Hague Rules said that the bills of lading is prima facie evidence of receipt as described in the bills of lading. The bills of lading has, the description about the quantity, the marking, etc. of the cargo that is received. Hague Visby rules, they strengthened this statement further. They said that the earlier part is okay, prima facie evidence of the goods received as described therein. But additionally it said that, however, proof to the contrary is not admissible when the bills of lading is in the hands of third party who's acted in good faith, right? So that person should not be misled. You have described something in the bills of lading, he should not find something else. You have described the condition of the cargo, he should not find the cargo in deteriorated condition. For that matter, the golden rule is whatever information is there in the bills of lading, it should be true to the best of master's knowledge. I mean, he is not supposed to take a microscope or a lens to check the quantity and quality of the cargo, but he should use due diligence. I mean, he should be careful. He has to write down remark with reasonable care. That is what is said by the court, which means that he is not required to open, say for example, a container, every container, right? But if he wants to open some container, the provision should be there so that he is able to check the container in case he suspects. The idea of this is, it shouldn't happen that master says that, oh, I have signed the bills of lading, but I have actually not loaded the full cargo and here is the evidence. No evidence will be allowed. The court will not allow that evidence. Or he cannot say that actually the cargo was damaged, but I thought I will give clean bills of lading. No, that is also not allowed. So you cannot deny the description which you have given in the bills of lading, right? And if he is, supported by certain indemnities, those indemnities will fail, Just a prima facie evidence is something which can be overturned by a better evidence. Now let's talk about delivery. Delivery is an obligation as per the contract of carriage. Now the carrier is supposed to deliver the goods. Delivery is one thing, right? And that other thing is the carrier is discharged from all the liabilities. The discharge of all the liabilities is different than just the responsibility of delivery, right? So what is this discharge of all the liabilities? The Hague Rules states that the carrier and the ship shall in any event be discharged from all the liabilities whatsoever in respect of goods unless suit is brought within 1 year of their delivery or of the date when they should have been delivered, right? So what is the difference in Hague Visby rule? In Hague Visby rules they said that this period may be further extended. But what is required for that? This period may be further extended by the mutual agreement of the parties. So mutual agreement is necessary after the cause of action has arisen. So let us say in a particular situation goods are delivered successfully, and subsequently after say 3 or 4 months the receiver feel that there's something is not very correct and there can be some cause of action. So now he wants to extend the date. It should happen that after 1 year of delivery he is not able to take any action. So he intimates the other party, that is the carrier. He says that I have intentions, but there is some delay, there are some problems, I need to survey it properly, and I feel that there is possibility of delay. So the date can be further extended by mutual agreement. So for the mutual agreement, what is required is the receiver, of course, he has to be vigilant. The receiver has to be justified, and he is benefited by this. On the other side, there should be positiveness with the carrier. It's not that you are doing business today and tomorrow you won't be doing any business. You have to have good name in business, right? So I assume that there is mutual cooperation between them, and they agree upon a date, the extended date. So this is what has come from Hague Visby rule. So a lot of receivers are going to be benefited, particularly in certain countries where the things move very slowly. Now this particular thing, that is the extension of date, is subject to 6 bis. Now 6 bis talks about indemnity. 6 bis says that an action for indemnity against a third person may be brought even after the expiration of the year provided for, if brought within the time allowed by the law of the court seized of the case. However, the time allowed shall not be less than 3 months commencing from the day when the person bringing such action for indemnity has settled the claim or has been served with the process in the action against himself. Let us try and understand. Here is the ship owner or carrier. Now, as we know that charter party is the agreement of ship hire between the charter and the ship owner. Now, carrier discharges the cargo, and here is the receiver. Now, in the charter party, sometimes it is agreed that for certain losses, the ship owner would be indemnified by the charter. So, we are talking about the indemnity, which is like a protection subsequent to the loss that is suffered by the ship owner. Okay, so as per the charter party, subsequently the ship owner is going to be indemnified. But let us say what happens here. Let us see what happens here. Receiver has a certain claim, and that claim is settled by the ship owner. But ship owner feels, as per the charter party, he is going to be indemnified by the charter. Now, when the ship owner has settled the claim, this is what it says, that the period of 1 year can be further extended. As far as the indemnity is concerned, the ship owner, if he has to be indemnified by the third party, so if the court allows that period should not be less than 3 months starting from the date when the ship owner has been served with the notice or he has settled the claim. Let us now talk about the limitation of liability. Neither the carrier nor the ship shall in any event be or become liable for any loss or damage to or in connection with goods in an amount exceeding £100 sterling per package or unit, or the equivalent of that sum in another currency, unless the nature and value of such goods have been declared by the shipper before shipment and inserted in the bills of lading. Now this limit was increased, by 68 Hague Visby Amendment, and thereafter in 1979 there was this SDR protocol. The SDR protocol says, unless the nature and value of such goods have been declared by the shipper before shipment and inserted in the bills of lading, neither the carrier nor the ship shall in any event be or become liable for any loss or damage to or in connection with the goods in an amount exceeding 6.67 units of account per package or 2 unit of account per kilogram of gross weight of the goods lost or damaged, whichever is higher. So Hague Visby amendments say that unless before shipment, not at a subsequent date, before shipment, if the nature and value of the goods are declared, that means the bills of lading is ad valorem bills of lading. If the nature and value of the goods is declared, probably they can agree for a different maximum, but otherwise, in case of damage, the carrier will not be responsible, not liable for an amount more than 666.67 SDR or 2 SDR per kg, whichever is more. So in respect of limitation of liability, these alternate methods of deciding the amount once again was a point that favored the cargo interest. The declaration mentioned in subparagraph 5A, that is that paragraph we were just talking about in respect of limitation of liability, if embodied in the bills of lading, shall be prima facie evidence but shall not be binding or conclusive on the carrier. We must understand what is the meaning of this, shall not be binding or conclusive on the carrier. Now they said that if you load something whose value is more, the two parties can, that is the shipper and carrier, can decide what is the limitation of liability different than 666.67. They cannot agree for a lesser liability, but they can decide under Hague Visby rule. If they have to decide about the limitation amount, it has to be higher than that. When the shipper has declared the value, that value amount does not become binding on the carrier. What is the meaning that it is not binding on the carrier? When normally what happens is when a package value is declared and it is expensive cargo, right? The carrier will also ask for a higher freight, right? Because the value is more, responsibility is more, so the freight also should be more. But it is not binding on the carrier. In fact, shipper is expected not to do misdeclaration, otherwise he will lose his rights. So coming back to the carrier, in case he has to pay the unlimited liability, then the value of the goods are not as per the declared value. The value of the good will be by the methods which are prescribed in the Hague Visby amendments that we will see now. It shall be calculated by reference to the value of such goods at the place and time at which the goods are discharged from the ship in accordance with the contract or should have been so discharged. The value of the goods shall be fixed according to the commodity exchange price, or if there is no such price, according to the current market price, or if there is no commodity exchange price or current market price, by reference to the normal value of the goods of the same kind and quality. So this allows for deciding the maximum value of the goods that is damaged in case there is reckless damage, in case the carrier has to pay unlimited liability. Next we talk about a change that considered containerization. So Article 4, paragraph 5C says, where a container, pallet or similar article of transport is used to consolidate goods, the number of packages or units enumerated in the bills of lading as packed in such article of transport shall be deemed the number of packages or units for the purpose of this paragraph as far as these packages or units are concerned, except as aforesaid, such article of transport shall be considered the package or unit. So this change in respect of consolidation aims at the containerization. It is possible that container has got some homogeneous bulk cargo or bags, or it is also possible that container has got the cartons and packages, and it is expensive cargo. So a shipper may want to declare the cargo as the packages or the cartons inside the container, and when he has declared so in the bills of lading, then when calculating what is the limited amount of liability, it will be considered as so many packages. So it depends on whether those packages have been declared in the bills of lading or not. Now one problem comes in here. If there is a less expensive or a low expense cargo, which is, say, just for understanding this concept, let's say there are only bricks and they are inside the cartons and various packages are put inside the container, and it is declared that there are 40 packages inside the container, right? So net value of the container is not so much, but limitation of liability amount can be very high if, say, 20 or 30 packages have been declared for that container. Hague as well as Hague Visby rules are very unique in respect of the exceptions which are provided. 17 exceptions. I'm going to talk about 4(2)q exception. Let us see what it says. It says, neither the carrier nor the ship shall be responsible for loss or damage arising or resulting from any cause arising where actual fault or privity of the carrier is not there, or where actual fault or neglect of agent or servant of the carrier is not there. Even if there is a cause which is not mentioned in these 16 subparagraphs, even if there is a cause of that type, so long as there is no fault or privity of the carrier, or there is no fault or negligence of the servant. Hague Visby rule also does not change this part. There is a limited liability when simply there is a fault. There is something very special stated in 5e. 5e says that neither the carrier nor the ship shall be entitled to the benefit of limitation of liability provided for in this paragraph if it is proved that the damage resulted from an act or omission of the carrier done with the intent to cause damage or recklessly and with the knowledge that damage would probably result. So when we read Article 4, paragraph 2q, it appears that there is an element of vicarious liability. Vicarious liability means in case the servant or agent makes a mistake, the ship owner or the carrier is responsible, because it says that if the servant or the agent is at fault, when they are at fault, right, then you will be exposed, the carrier will be exposed to limited liability. In Hague Visby amendment, where it says that the carrier and the servant, both, they are entitled with this benefit of limitation of liability. Both will lose the benefit of limitation of liability if the damage that is caused is reckless or it is done intentionally. So Article 4 bis elaborates on this. Article 4 bis 1 says the defenses and limits of liability provided for in this convention shall apply in any action against the carrier in respect of loss or damage to goods covered by a contract of carriage, whether the action be founded in contract or in tort. This means that limitation of liability would be available even if the action is in tort. Agreement is something which is a contract between the two parties. Yes. So as per agreement, if carrier does not comply with certain condition, then of course there is action, and of course the limitation of liability would apply there. But even if there's something which is not part of the contract, that means if there is a mistake that is done, or rather I would say if there is a wrong that is done, that means if action is brought in tort, even then the limitation of liability is applicable and it is available. 4 bis 2 says if such an action is brought against the servant or agent of the carrier, such servant or agent not being an independent contractor, such servant or agent shall be entitled to avail himself of the defenses and limits of liability which the carrier is entitled to invoke under this convention. That means if the action is brought even against the servant or agent, even he can avail this opportunity. The limitation of liability advantage is applicable to the servant and agent also. 4 bis 3. 4 bis 3 says the aggregate of the amounts recoverable from the carrier and such servants and agent shall in no case exceed the limit provided for in this convention. That means it is possible that the liability is apportioned between the carrier and the servant. 4 bis 4 says, nevertheless, a servant or agent of the carrier shall not be entitled to avail himself of the provisions of this article if it is proved that the damage resulted from an act or omission of the servant or agent done with the intent to cause damage or recklessly and with the knowledge that the damage would probably result. Limiting of the liability would not be possible if the damage is done intentionally. There is this Article 9, which is an independent article, right, that has been a kind of inserted via Hague Visby Amendment. So Article 9 says, this convention shall not affect the provisions of any international convention or national law governing the liability for nuclear damage. Next we talk about Article 10. Article 10 is application. One of the most important aspect of any particular convention, rule, etc. is the application. So Hague Rules said that these rules will apply only if the bills of lading are issued in the party state. Party state means the states which have ratified the Hague Rules. But Hague Visby Amendment has got 3 avenues by which the Hague Visby rules can apply. The provisions of this convention shall apply to every bill of lading relating to the carriage of goods between ports in 2 different states. If A, the bills of lading is issued in contracting state, or B, the carriage is from a port in contracting state, or C, the contract contained in or evidenced by the bills of lading provides that this convention or legislation of any state giving effect to it is to govern the contract, whatever may be the nationality of the ship, the carrier, the shipper, the consignee, or any other interested person. So it says that if the bills of lading are issued in a party state, or the cargo is being loaded in a party state, or in clause paramount. So what is this clause paramount? Clause paramount is part of bills of lading or charter party, etc., whereby it says that the Hague Visby rules will apply, or Hamburg rules will apply, or national legislation giving effect to certain rules will apply. So unless there is a compulsory mandatory legislation to be applied by the clause paramount, it can be ensured that Hague Visby rules will apply.